Want to remind you, both of you are experienced practitioners, so you understand the rules and the procedures that we follow, and we will be following those same rules, the same protocol, as if we were in the courtroom today. Each side will receive 15 minutes to make its oral argument. If you're the appellant and you have reserved rebuttal time with Mr. Hibner, you'll receive that rebuttal time after the appellee makes its argument. Before we get started, I want to introduce our panel for this morning. It's Judge Arnold Golden from Memphis, Judge Thomas Skip Frierson from Morristown, and I'm Steve Stafford from Dyersburg. And we will be conducting that oral argument. Mr. Hibner, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
Renee Downs versus Glenn J. Williams, MD, et al.
Hear from the appellant.
Thank you. Your Honor, please. My name is Gene Lorenzi. I represent the appellant in this matter. My able adversary, Julia Kavanaugh, represents the defendant, Dr. Williams. This is an appeal from a trial court grant of a motion for summary judgment in a wrongful death medical negligence claim. Prior to the grant of summary judgment, the court, in response to what I'm going to get into later, a motion to exclude plaintiff's expert based on a loss of chance theory rule, the court could only look at expert testimony in a discovery deposition. We felt that that was error. We felt that the court should look at both the expert report. We felt the court should look at the discovery deposition. And importantly, we filed an affidavit, which we believe did not contradict anything, but again, set out opinions for the trial judge. Essentially, what we have is, again, the trial judge only would, she refused to look at, respectfully, the anything but the discovery deposition. And I'm going to get into the discovery deposition. But before I do that, I do think I need to unpackage some facts here. I'm not going to, they're well cited in the brief. There's really no dispute among the facts. What we had, Ms. Jones, the decedent here, was a 62-year-old woman, and she was admitted to the hospital. She was in there for about a month. She had some breathing problems. Dr. Williams is a pulmonologist who assists with breathing problems, and she was treated by Dr. Williams. Shortly before she was going to be discharged, what Dr. Williams decided to do was to do a thoracentesis. And thoracentesis is a procedure where you're going to stick a needle in you, and you're going to try to withdraw some fluid between what we call pleura, which is essentially lining of the lung. There was an older x-ray that showed that this might have been a problem. There is a dispute whether that the effusion actually existed. However, the doctor decided to do the procedure. What he was going to do then, he was going to take a needle and he was going to inject the needle through her back, and that's what he did. What he did is he sat her up in her bed. This was all done bedside. He sat her up in her bed. He stuck a needle into her, and he withdrew blood. He again stuck a needle in her a second time, and he withdrew blood. At that point, he recognized there might be something wrong. Essentially, what happened after that was her lungs filled with blood. She died. Due to what our experts said was asphyxiation. I don't think really there's any real dispute about that. So importantly, what was available to the doctor, which our expert, I'm going to get into in just a second, suggested you could have used ultrasound guidance. It's a simple bedside little computer to see where you're going with the thoracentesis needle. Very simple. Very cheap. The x-ray prior to the thoracentesis was done bedside. It's not like it was done 30 years ago where you have to wheel the patient down to a large CT. These can be done bedside. He decided not to do that. Importantly, Ms. Jones was on blood thinner, meaning she was at a high risk for a cut, a puncture. She was on warfarin. If she was cut, she had a greater risk of bleeding. She unfortunately passed away. We felt what Dr. Williams did was violated the standard of care, and what we did, as you're supposed to in every medical negligence case, we retained an expert. Our expert, prior to filing suit, same report, issued a report. And essentially in his report, which we stated in our brief, he said that, in my opinion, the thoracentesis performed by Dr. Williams led to immediate complications and resulted directly in her death. In conclusion, Dr. Williams performed an elective thoracentesis for unclear reasons on an anticoagulated patient at bedside, guided by a 2-day-old chest film. This was reckless, exposed the patient to needless risk, directly caused her death. The foregoing, in my opinion, is to a reasonable degree of medical certainty. We filed the report. We offered it to the trial judge, obviously offered it to adversary counsel prior to her taking a discovery deposition. This is where things start to get a little confusing. How we arrived at this appeal today. Ms. Kavanaugh, rightfully so, decided to take the expert's deposition. And in the deposition, there was a lot of questions asked about risk, about whether had he, Dr. Williams, used this ultrasound guidance, there would have been a decrease in risk. I want the court to know we never alleged loss of chance. We never suggested loss of chance. It was never our theory. It was never argued. The complaint said failure to use ultrasound guidance violated the standard of care and was the proximate cause of her death. In the deposition, what defense counsel did was start asking questions regarding risk. And she relied on a case, Gall, which was argued to the trial court. Gall was argued, and Gall is loss of chance is a theory that permits recovery due to a delay in treatment. That's not what the plaintiffs argued. It's not what Dr. Cramen said in his deposition. It's not what he said in his affidavit. Now, I guess we're at a crossroad here, because we believe the court should have looked at the entire record. That's what Rule 56 says. Without question, they should look at the expert report. They should look at the discovery, interrogatories, the deposition, and the affidavit.
Let me pose a question to you. I don't know that I disagree with what you're saying, but essentially, though, the trial court looks at the statement of undisputed material facts and what is cited in that statement. So was the report, was the specific parts of the discovery deposition, were they all cited to the court?
Yes, absolutely, Judge. It was all cited in, I think, in the disputed and undisputed facts. Importantly, after the deposition, facts that as we submitted our disputed and undisputed facts, defense counsel, defendant, said, Your Honor, you cannot look at the affidavit. They said that's off limits. And this is where my argument diverges a little. I want to argue that I can't find any case law that seems to suggest that you can only look at the discovery deposition and you can't look at the affidavit in response to Rule 56. I can't find anything. All the cases that were cited have to do with, a lot of them, qualifications. I can get into that in a minute, but I really want to address, there was enough, and it's clearly cited in our brief. Even if the court were to say, well, Judge, you were right, don't look at that, even though the rule provides that you could file an affidavit under Rule 56, even though the rule provides that, If there's some case law that I'm missing, and your honors are going to suggest the discovery deposition is enough, I still believe in the discovery deposition, Dr. Cramen said enough to withstand summary judgment.
What does the rule say?
I'm sorry.
What does Rule 56 say about what you are able to rely upon?
Affidavit, the whole record, Judge. I mean, I want to parse this, but just everything. And by everything, I mean the pleadings, the report, the affidavit. I want to make very clear that the affidavit that we submitted did not contradict anything. It restated his opinions from the report. It essentially restated his opinions from the deposition.
Well, let me get a little more specific with you. And why did the trial court not consider the affidavit? Was it because the affidavit contradicted something or had information that was inconsistent with the discovery deposition? Or was it simply, I can't consider the affidavit?
Judge, I've got, it's unclear. Can I be very candid? I think it's unclear from the record. This is what the court said. The court does not feel the affidavit filed subsequent to the deposition to be appropriate for consideration. An affidavit is not subject to cross-examination. So essentially what she said was the only thing she was going to rely on was the discovery deposition. And in the discovery deposition, the questions that were asked violate Kirkpatrick. Kirkpatrick stands for the proposition of more likely than not. The questions were very artfully asked, but they had to do with whether using ultrasound guidance would, quote, eliminate the risk. Dr. Cramen, you cannot quantify the risk.
When you say, when we're looking at more likely than not and Kirkpatrick, are we talking about what she or what the trial court relied upon to discount the deposition or the affidavit?
Judge, once again, I'm not trying to, I wish I knew. I mean, I could not really, it looks like to me, the only thing I can say is the facts kind of go to intent. She wasn't going to look at the affidavit. She just wasn't going to do it. And the affidavit.
So it was not simply directed at the deposition. It was what, a general inclusive denial?
That's what I believe, Your Honor. I mean, the order is, we cited this in our brief. The order is in a way very sparse. The question is, did he say enough? Report, I'm repeating myself, report, affidavit, and deposition, which I think he did. Again, I cannot stress enough. If you believe, if this court believes that for some reason, the only thing we're going to look at is a discovery deposition, which they have every right to take, which I can't use at trial, but they have every right to take if we're going to have to try our case. If I'm going to have to literally ask questions, ask my entire case in that discovery deposition, the reports, all the facts, everything, then I think this court needs to let the bar know. That's my problem with this. I'll address that a little in my rebuttal.
All right. Thank you, sir. We will now hear from the appellee.
Thank you. Good morning. I'm Julia Kavanaugh, and I represent the appellees, Dr. Williams and Mid-South Pulmonary. Let me start by addressing the affidavit. Mr. Lorenzi had read some of the language in the court's opinion regarding that, or in the order. But the order also states that in this case, the affidavit appears to be drafted solely to avoid exclusion of the testimony and resulting summary judgment. That's a reference to those.
I found that language interesting because what else would the affidavit be used for?
Well, and in this case, that was clearly the purpose, but that's a reference to those so-called sham affidavit cases, which were cited in the reply in the trial court. And those stand for the proposition, basically, that Mr. Lorenzi kind of referenced this, that if an affidavit contradicts a witness's deposition testimony and it's not adequately explained, that may be disregarded. So that was, in our view, the basis for failing to consider an affidavit, not that I can never consider an affidavit on summary judgment.
But did the trial court say that?
No, that's all. This is the entire language is the court does not feel that the affidavit filed subsequent to the deposition to be appropriate for consideration. An affidavit is not subject to cross-examination, and in this case appears to be drafted solely to avoid exclusion of his testimony and result in summary judgment. That is the language.
Doesn't talk about competence or information that shouldn't be considered, anything.
No, Your Honor, it does not.
Doesn't that essentially violate our Smith versus Lakeside rule?
The Smith Lakeside rule being that the trial court
explains why it grants or does not grant, or well, why it grants summary judgment, essentially.
Well, and it's a little bit convoluted in my view in this case, because there are two separate motions that are addressed in one order. Of course, there's the motion to exclude and then the motion for summary judgment. In our position is, while this, and I agree the order is a little sparse, but on the summary judgment issue, the sole basis for summary judgment motion and for the grant of that, I think it's clear from the order, is the determination that the expert's causation opinion was not admissible.
Let me ask you about that, Ms. Kavanaugh. We're talking about the court's language in this order where it says his testimony fails to state with requisite specificity that Dr. Williams, in fact, breached the standard of care. So really, we're talking about the standard of care here, and instead repeatedly states in different contexts that an ultrasound of CT guidance would have been better. I reviewed Dr. Craman's your discovery deposition, and you did an excellent job. But I was wondering whether I was looking at the same case when I read this deposition. I mean, Dr. Craman's just starting with the procedure itself. He says the problem I have is that he stated it was a therapeutic cap. She did not need a therapeutic cap. It wasn't unreasonable to do it, but the discharge should have been canceled. She should have had appropriate imaging, and then it should have been done. He said, I would say that the way he did it, the way it was done, was a gross deviation of the standard of care. It was done as almost a last-minute thought. Here, before you go home, let me stick a needle in you. That was totally unreasonable. If he wanted to, there would be a way to do it. The way he did it was a gross violation of the standard of care. And then he goes on to say that in his training, even in the 70s, we would never do it that way. He said, that's the way I was trained. I think any pulmonologist I've ever known would have done it that way. All of these manners of visualizing these things easily, quickly available, a CT scan at the very least, but not even a lateral chest film was taken. And then he says, you can't go in there blind. You don't go in there blind. I mean, this was a cornucopia of deviations from the standard of care. I'm just perplexed as to what the court could have possibly meant when she said that his testimony fails to state with requisite specificity that there was a breach of the standard of care. All these things that y'all have been arguing about in terms of much less and whatnot, that seems to me to apply to the risk. You even asked a question about the risk, because Dr. Craman's apparently said there wasn't sufficient data, but you even asked him a question about that in the deposition, about it doesn't eliminate, let's see. Your opinion, I believe, is that the lung laceration happened because he just couldn't see where he was going, and it was due to basically operator error. He says, yes, that doesn't eliminate the risk. And he said, what it does is tell you, you know where you can safely put the needle. And you then said, and actually at least one of the studies is it was a 4% risk. And he says, yes. And that was with ultrasound guidance. We don't deal, there's no way to make it zero. So even in that situation, you're talking about essentially, if you want to try to analyze that statement, a 96% chance of making it better if he used ultrasound guidance. I'm not, what are we arguing about here? I've got a real problem with the court saying that there was no requisite specificity regarding a breach of the standard of care. Can you explain that to me?
Let me see if I can answer that question. So the motion that we filed was to exclude the causation opinion as speculative. It was not addressed to the standard of care opinion. It was it was challenging, basically tying what the specific alleged deviation from the standard of care was, which was the imaging decision, to the harm, to the complication. So that was the basis of the motion. I believe what that language may be in reference to is there were several places in the deposition where Dr. Kramen kind of said, well, he can't say for sure whether ultrasound specifically was required, because that depends on what a CT would have shown. That may be what that language is in reference to.
Well, let's assume that like in every summary judgment case I've ever seen, that an affidavit can be filed and considered, where he says in his affidavit, my report makes it clear, and he's talking about his report, which was previously filed. My report makes it clear that, in my opinion, Dr. Williams' negligence caused Patricia Jones' death, and that had Dr. Williams not performed this thoracentesis in a negligent manner, it is more likely than not that Patricia Jones would not have died. That's pretty clear. And apparently says that in his report.
Well, let me take this opportunity to address what the report actually does say, because I do think that's important. The plaintiff has stated in their brief and it's referenced in the affidavit, that the report says the negligence caused.
Well, before you explain that, I think Judge Stafford was asking this. Explain to us why this affidavit cannot be considered.
Well, our position is that it is inconsistent with the causation opinion, because when Dr. Kramen was asked the kind of magic words question by plaintiff's counsel in the deposition, which is, essentially, you have an opinion more likely than not, reasonable degree of certainty, whether the laceration would not have happened had ultrasound been used. He said, I think it's much less likely. The affidavit then said— Was he
talking about risk? Do we know whether he was talking about risk, the risk there?
I believe he was talking about, whether or not this,
we were talking about risk versus causation, I guess. In other words, there's that part of it. I'm trying to see what the conflict is here with the testimony in the affidavit. I'm having a real problem with that.
Well, in our view, the conflict would be that his deposition testimony was essentially, he believes that the harm would be much less likely to have occurred, whereas in the affidavit, he then kind of recites the magic words that he kind of qualified when plaintiff's counsel asked him those questions in the deposition.
I mean, he basically says, you shouldn't go in blind. Here, the doctor went in blind. He punctured the lung twice and killed this woman. And that seems to be what his testimony is all about, that it violates the standard of care, that he basically says it was a gross violation of the standard of care. And then he says in his affidavit that it was that it's in his opinion that the negligence caused her death. Maybe I'm crazy. I'm missing something here. I don't know. I'm not sure. You're very persuasive, Ms. Kavanaugh.
If I may, I'd like to address what the expert report does say, and let me kind of circle back for a second, because as what the specific deviation alleged in this case was in the complaint, and it has to do with the imaging decision. It doesn't have to do with the fact that he did it at all. He made some comments about that, but he agreed in his deposition that doing it, just doing the procedure is not a deviation from the standard of care. And so the question is, what's his opinion about whether the imaging decision is what caused the harm in this case? And so now let me address the expert report. What the expert report actually says is a little bit different than that, I think. It says that the thoracentesis caused by Dr. Williams, or performed by Dr. Williams, led to immediate complications. Then with respect to that specific issue, with respect to the imaging decision, it says that that decision, or the choice of imaging, greatly and unnecessarily increased the risk of complications. So it doesn't say that it caused the complications, it says that it increased the risk of complications. And I do think that his deposition testimony as a whole reflects that that is his opinion, that basically the imaging decision increased the risk or made it more likely that this would happen, and that is not, that does not comport with the standards.
And he also says in his affidavit, while I cannot state the precise decrease in risk, which I think is exactly what he said in his affidavit, I mean, in his deposition when you were questioning him about it, and you raised the idea that there was a study showing there was a 4% risk. While I cannot state the precise decrease in risk of lung laceration, which is what I'm getting from his testimony about this less likely risk issue, by using available imaging guidance technology, it is my opinion that had Dr. Williams used this technology, it is more likely than not that he would have avoided puncturing Ms. Jones's lung, which follows his testimony about you don't go in blind when you have the technology to do it, and it's been the standard of care for, according to him, since the 70s, or at least since 2015. I think he used a 2015 date, but clearly he said that's the way they did it in the 70s.
Well, and actually, Your Honor, if I may, his testimony was he last did these procedures in 2009, and they did not have ultrasound guidance or CT imaging. He did not do it that way. He did it the way that our doctor did it, using physical exam techniques and a chest X-ray. And that was.
I'm sorry. Go ahead.
Oh, and I'm sorry. That was another. Issue that was raised in the trial court. Is not only are there no studies to kind of quantify what difference in, how much less likely this is to occur using the different imaging studies, but he doesn't actually have any personal comparison because he was, he is not, it was not available at his facility when he was involved in those procedures.
All right, thank you.
All right, if there are no other questions, I will turn it back over. Thank you.
Thank you. We will hear from Mr. Lorenzi in rebuttal. You're muted, Mr. Lorenzi. Still muted. According to what I'm looking at, you're still muted. There you go.
Technologically challenged here. Sorry.
As are all of we.
I think the problem I have, what the defense would like to do in every case, I'm going to speak more broadly here, is look at more likely than not under Kirkpatrick and then quantify that. Ms. Kavanaugh is a very good lawyer. And if you look at Gall, that's exactly what the court did in Gall. They tried to get the doctor to say, well, you can't say how much of this tissue was missing. Therefore, you can't say more likely than not that the surgeon violated the standard of care. And that's exactly the same thing. We argued that to the trial court. That's exactly what we're doing here. And the questions elicited in the deposition, that's exactly where they were going. They were going to, can you eliminate the risk? Can you quantify? And my fear was throughout this, what I guess kept me up at night was the court would issue a ruling saying, well, that's where we're going. We're going to start talking about quantification. We're going to start talking about elimination of the risk. My suggestion is that goes to the weight. The simple way to resolve this claim is, I think it's Judge Golden, is look at the deposition, but look at the affidavit. It's very simple. I think the court, respectfully, I think she was somewhat confused. I think this matter should be sent back to the trial court. Let us go to trial on this matter. Thank you.
All right. Thank you, counsel. We appreciate your argument. We appreciate you participating with us via Zoom. We will take this matter under advisement and will try to render opinion at the earliest possible time. I want to again acknowledge Mr. Hibner and the AOC staff and Mr. Hibner's staff and how competent they are in making this work for us. Mr. Hibner, if you'll recess court to the call of the next case, please.
This honorable court is now in recess until 1 p.m.